All right. Good day, Crime Talk aficionados. We are going to have a special show for you today, and it is in regards to the Supreme Court. Now, obviously, we talk about lots of crime cases, and we try to bring you the legal analysis. But what is criminal law? It is constitutional law. All of the fundamental rights and the rules that everyone has to play by come from the Constitution. And so we're going to focus today on some Supreme Court cases that are only truly criminal law related. And we'll get into a couple of them here. So I hope you enjoy. I'm going to try to bring you more shows like this. And I know it's kind of dorky and nerdy, but hey, if you're a Crime Talk aficionado, you're into this stuff. And if you aren't, you should be. All right?
All right, lawyer.
So, the Supreme Court of the United States is entering the concluding stages of its 2025-2026 term, during which it will issue decisions in several pending criminal law matters and conduct oral arguments in additional cases of substantial importance to the administration of justice. Now, the court has scheduled its final session for oral arguments on April 20th through April 29th, and then it will resume releasing more prominent opinions beginning this Friday. Now, amid a mix of civil disputes, including those concerning birthright citizenship and the dismissal of the Federal Reserve governor, a notable cluster of criminal law issues stands out for their potential impact on defendants' rights, sentencing procedures, and constitutional protections. So let's do a detailed examination of the docket and what it reveals that criminal law and closely related subjects continue to account for a significant share of the court's workload this term. Of the 23 cases remaining for argument over the next 2 months, 5, so approximately 22%, directly address core criminal law questions, while 6 others bear important connections to criminal proceedings. In total, roughly 29 of the 57 cases argued during the term this past fall into that category, a proportion consistent with historical patterns observed in Supreme Court litigation. Now, several criminal law cases argued in the fall of 2025 await resolution, with decisions likely to appear in the near term. One prominent matter is Villarreal v. Texas. That was argued on October 6, which concerns the permissible scope of a trial judge's instructions prohibiting a testifying defendant from discussing his or her testimony with his counsel during the overnight recess. The case raises fundamental questions under the Sixth Amendment regarding the right to the assistance of counsel, an issue with practical consequences for trial practice in federal and state courts. Now, 3 sentencing-related cases from the same period also are pending. Fernandez v. United States and Rutherford v. United States, addressing distinct aspects of the First Step Act's compassionate release provisions enacted during the first Trump administration, which allow certain inmates to seek early release on humanitarian grounds. Many anticipate coordinated opinions in these matters. And then separately, you have Rico v. United States, which examines whether periods during which a defendant has absconded from parole or other non-custodial supervision should be excluded from statutory limitations periods. So, should the statute of limitations toll while somebody is gone? That's the way it is in most areas of the law, but someone's always raising good arguments, I guess. Now, of particular note is Ham v. Smith. This case was argued on December 10th, which evaluates the standards lower courts must apply when determining whether a capital defendant suffers from a mental disability that under the 8th Amendment and the precedent established in Atkins v. Virginia renders execution unconstitutional. Now, some have suggested the ruling could represent a significant development in the court's approach to capital punishment, especially given changes in a court composition since Atkins and the ongoing trends in death penalty sentencing. Now, we have a couple of cases that are set for oral argument in the spring. 5 cases squarely centered on criminal law are slated for argument in the coming weeks, offering the court opportunities to clarify important constitutional and procedural principles. On March 2nd, the court will hear the case of United States v. Jimeni, a Second Amendment challenge to a so-called long-standing federal statute that prohibits firearm possessions by individuals who are unlawful users or addicted to controlled substances. And this dispute centers on the statute's application to habitual marijuana use and the appropriate role of historical tradition in evaluating such restrictions, building on recent precedent in firearms jurisprudence. Now, the following day, on March 3rd, we have Hunter v. United States, which concerns the interpretation and enforcement of appellate waivers commonly included in plea agreements. Now, these waivers, in which defendants agree not to challenge their convictions or sentence on appeal, have generated conflicting approaches among federal circuits. The case explores whether such waivers admit exceptions, particularly when a sentencing judge informs the defendant of appellate rights, and whether prosecutors' silence in response to such statements constitutes a waiver by the government and their reliance on the agreement. These cases are going to highlight the broader tensions between plea bargaining efficiency and appellate oversight of sentencing consistency. And when the government here first tried to do appellate waivers, which basically says, hey, you're pleading guilty, you can't appeal unless the judge gives you an illegal sentence, the court here normally wouldn't take those. I remember when I was in a very awkward situation, I had a client who had a very good plea bargain as it related to her case and sentencing, but I was fundamentally opposed to the appellate waiver. The court was opposed to the appellate waiver, but I really wanted this deal to go through because it was a good deal. So I remember having to argue, saying, Judge, this is contract principles. We're giving something up in exchange for that. It's called consideration, benefit of the bargain, and the judge should go along with it. Ultimately, he did. And unfortunately, now every case, at least in the circuits that I have practiced in, all include appellate waivers. Now, normally when you plead guilty, though, you're giving up all your trial rights, so there's really nothing to appeal. But if the judge does make a mistake on sentencing, you'd like to be able to appeal it. So it's going to be interesting if the courts say no appellate waivers or they say it's something that can be negotiated in. It's going to be very interesting. And then on March 30th, we have the case of Abu Amo versus the United States, which examines constitutional venue requirements under Article 3 and the Sixth Amendment Vincense Clause. In this case, the defendant allegedly emailed false documents from Washington State to FBI agents based in San Francisco and was tried in California federal court. The case tests whether the venue may be established based on the contemplated effects of a crime occurring in another district, raising foundational questions about the physical and technical boundaries of criminal trials in an era of electronic communications, right? The Constitution says that you had to be tried where the crime took place. So was it, in Washington, or was it in San Francisco, in California? The court's going to have to decide that. The next day, March 31st, the court will consider Pitchard v. Kane, a capital case involving application of Batson v. Kentucky, which is a case that prohibits race-based peremptory strikes of jurors. And in the petition filed by a black defendant on Mississippi's death row, he challenges a prosecutor's strike under the highly deferential standard imposed by the Anti-Terrorism and Effective Death Penalty Act, known as the AEDPA. Now, the ruling will address whether the state court's waiver findings was unreasonable and will likely illuminate ongoing debates over federal habeas review on state criminal judgments. And then finally, on April 27th, Chatry v. United States presents a significant Fourth Amendment question involving geofence warrants. Now, these orders compel technology companies such as Google to search anonymous location data for millions of cell phones to identify individuals present at a specific place and time relevant to a crime. This case, which arose from an armed robbery investigation, asks whether such broad digital searches comply with the amendment's protection against unreasonable searches and seizures, extending the court's earlier analysis in Carpenter v. United States to the rapidly evolving surveillance technology. Now, two additional cases related to immigration and enforcement and deportation practices include Nome v. Al Otro Lado on March 24th and Bondi v. Lau are expected to influence current public policy developments, but don't really fit into the pure criminal law analysis. So, like I said, the Supreme Court has already granted review in two further cases for the 2026-2027 term, ensuring continuity in its caseload. Now, neither appears to raise direct criminal law issues. One involves the Video Privacy Protection Act as the current term draws to a close, and we obviously have a steady influx of significant matters underscoring the court's role in shaping criminal procedure and protecting constitutional rights. Now I want to talk about the case Chatry v. United States and geofencing warrants. So the Supreme Court granted review in Okello T. Chatry versus the United States back on January 16th. Now, the petition for the writ of certiorari had been filed back in July of last year. Now, after multiple extensions granted to the respondent, the United States filed its brief in opposition on November of 2025. The petitioner then filed a reply on December 8th, and the case was set for oral argument on April 27th, the penultimate argument day of the 2025-2026 term. So the petitioner's opening merit brief and the joint appendix were filed on February 23rd, just the other day. And the amicus briefs supporting the petitioner's briefs were submitted back in August of last year. And the amicus briefs were filed by Project for Privacy and Surveillance Accountability, Inc., and the X Corporation. Now, the court granted certiorari limited strictly to one question presented in the petition: whether the execution of the geofence warrants violated the Fourth Amendment. And review of the second question concerning application of the exclusionary rule and the good faith exception was denied. So let's talk about the factual background and the geofence warrant process. So back in May, specifically on May 20th of 2019, an armed individual robbed the Call Federal Credit Union in Middle Latham, Virginia, stealing approximately $195,000. Surveillance footage depicted the perpetrator holding a cell phone to his ear while fleeing. With no immediate suspects, Detective Joshua Hilton of the Chesterfield County Police Department obtained a geofence warrant on June 14th, directing Google to search its location history database, what's known as their sensor vault. The warrant specified a 150-meter radius, approximately 300-meter diameter, around the credit union and a 1-hour window centered on the robbery's time, later expanded during the execution of 2 hours. Now, Google employs a standardized 3-step protocol for such a request. This anonymized initial response. Google searches its database for hundreds of millions of accounts and returns this anonymous device identifier: latitude, longitude, coordinates, timestamps, confidence intervals, and geolocation sources for all matching devices within the geofence parameter. In this case, 19 devices were identified. Then a narrowing request was sent. So law enforcement reviewed the anonymous data, and then they may request additional location points, often expanding geography or time for a subset of devices. In this case, the request was narrowed to 9 phones, yielding approximately 680 additional data points. So for devices deemed relevant, law enforcement requests subscriber identifying information, name, email address, and other account details that you use when you set up your accounts. 3 accounts were anonymized. One belonged to the petitioner, Mr. Chatty, who had enabled location history on his Samsung smartphone back in 2018. Chatry was arrested and evidence recovered during the investigation, including stolen cash and a firearm, which led to his indictment on charges of forced accompaniment during an armed bank robbery. He entered a conditional guilty plea after the district court denied his motion to suppress. A conditional guilty plea is you go through motions, you say, I'll plead guilty, but we're going to be allowed to appeal this particular legal issue. And if it comes back, then, we'll proceed from there. He was ultimately sentenced to 141 months in prison. The district court concluded that the warrant plainly violated the Fourth Amendment for lack of particularized probable cause as to every user whose data was swept into the search, but denied suppression under the good faith exception of United States v. Leon, which basically holds the fact that, hey, cops applied for it. They didn't know it was illegal. So they get to use the information. Anyway, good faith exception. They didn't do anything illegal. They just applied for what they thought was legitimate, and then they could use it. Anyway, the Fourth Circuit panel initially held that Chatry lacked a reasonable expectation of privacy in the short duration, voluntarily sharing the data. And then on an en banc hearing, which is all the judges, the Fourth Circuit issued a one-sentence per curiam affirmance on April 30th of 2025, accompanied by 9 separate opinions totaling over 100 pages. Judges were deeply divided on whether a search occurred, the warrant's validity, and the good faith application. Now, issues the court will hear, all right? The court will decide solely whether the execution of this geofence warrants violated the Fourth Amendment. Now, this framing requires resolution of 3 interrelated questions. First, did the government's compelled acquisition of precise retrospective location history data constitute a search under the Fourth Amendment? If so, did the warrant satisfy the requirements of probable cause? And did the warrant satisfy the particularity requirements, or did the multi-step process render it unconstitutional as a general warrant? The court expressly declined to address whether, even if a violation occurred, the evidence would be admissible under the good faith exception. So, what are the arguments? Well, Chatry contends that the government conducted a search when it compelled Google to search its database and produce his location history data. Now, under Carpenter, which is United States v. Carpenter at 2018, the United States Supreme Court case, held that such data is qualitatively different from traditional third-party records. It is comprehensive. It's logged approximately every 2 minutes with meter-level accuracy, including elevation, retrospective, enabling time travel reconstruction of movements, intimate, revealing visits to homes, churches, medical facilities, or even political events, and easily compiled. Users don't meaningfully voluntarily share this data with Google for law enforcement purposes. The opt-in process is frictionless and poorly explained, and smartphones are indispensable, obviously, in modern day life. So a property-based theory is also advanced that users retain ownership interest in their location data, which Google holds as a bailee. You know, when you drop your car off at the mall and you park in the valet, they're a bailee. They're responsible for the car when they have it, but it's still your car. So the warrant is facially invalid is the next argument. All right, you can't have a general warrant. So it did not particularly describe the place to be searched or the thing to be seized because it authorized a computational search of millions of accounts without identifying specific accounts in advance. The 3-step process delegated excessive discretion to Google and law enforcement to expand the scope of the search and select targets for anonymizing without additional judicial approval or particularized showing. Probable cause was lacking because mere spatial temporal proximity to the crime scene does not establish a fair probability that evidence of a crime would be found in any particular user's data. And this is the Ybarra v. Illinois case of 1979, a Supreme Court case. Anyway, the warrant thus permitted an exploratory dragnet of innocent bystanders, private information, the precise evil the Fourth Amendment was designed to prevent. But what's the argument for the United States? The government maintains that no Fourth Amendment search took place. And they argue that users who affirmatively enable location history voluntarily disclose their precise location to Google, bringing the third-party doctrine of Smith v. Maryland and United States v. Miller squarely into play. And they say that the limited temporal scope, approximately 2 hours, and the small geographical area distinguish this case from the weeks or months long comprehensive tracking at issue in Carpenter. The data represents a narrow snapshot of public movement at the time and place of a crime. So even assuming there was a search, the warrant was constitutionally sufficient. A neutral magistrate issued it on a showing of probable cause that the perpetrator, observed using a cell phone, would have location data revealing his identity among devices present at the scene. The geographic and temporal parameters were narrowly tailored to the specific offense, and Google's three-step protocol actually enhanced privacy by beginning the anonymous data and requiring further requests for additional disclosure. The staged process provides built-in narrowing that satisfies particularity in the digital context. So, is there any significance to individual liberty? Well, this case presents one of the most important Fourth Amendment questions of the digital era. A ruling in favor of the petitioner would affirm that Americans retain a reasonable expectation of privacy in their historical location data, despite sharing it with technology companies for personal convenience. And it would protect the fundamental liberty to move about freely without creating permanent government searchable records of one's daily life, associations, and private activities. And such a decision would reinforce the amendment's core purpose, preventing general warrants and a dragnet surveillance that allows the government to rummage through the private lives of citizens without individualized suspicion. Now, conversely, a ruling for the government could legitimize mass digital surveillance techniques that sweep in location data from thousands of innocent individuals whenever a crime occurs in a populated area. This would significantly diminish expectations of privacy in public movements, chill protected activities such as attending protests, religious services, or even medical appointments, and normalize a surveillance state in which technology companies become de facto extensions of law enforcement. What does it mean to law enforcement? Geofencing warrants have become a powerful investigative tool, particularly valuable if no suspect cases such as armed robbery, shootings, and terrorist incidents where only time and place are known. A decision finding a constitutional violation would require law enforcement to develop more narrowly tailored approaches, potentially successive warrants for anonymizing somebody in their steps or higher thresholds of particularized suspicion, potentially slowing investigations and increasing reliance on traditional methods. It would also prompt technology companies to further restrict data retention or disclosure policies. And a decision upholding the warrants would validate and likely expand the use of this technique nationwide, enabling faster identification of perpetrators and enhancing public safety. However, even a favorable ruling may include limiting language on scope or the process to guard against abuse, and the outcome will provide essential national uniformity and guidance to magistrates, officers, and lower courts that have to navigate this rapidly evolving surveillance technology. Now, the Supreme Court's decision will more than likely be expected at the end of the current term. It's going to shape the balance between effective law enforcement and the protection of individual liberty for decades to come. It represents a critical judicial effort to adapt foundational constitutional principles to the realities of the pervasive digital tracking in the 21st century. So as you can see, ladies and gentlemen, there are good arguments on both sides. Individual liberty, limits on government, doing these dragnet searches, saying we're not sure who we're looking for, but we'll know it when we find it. And government saying this is the best tool we have to solve crime. And you have no expectation of privacy because your data is with a third party. It's not even yours. This is why the Supreme Court, I guess, makes the big bucks. But at least 5 are going to have to say one particular way. individual liberty trumps the government's ability to solve crime in an expeditious way, and go back to older techniques that don't involve such technology? Or are they going to say, maybe this case was not a good case for this, or it was because the guy had a phone, so they knew the person had a phone, and it wasn't just this completely anonymous search, dragnet search for that phone data. And maybe they'll make some rules for it. We don't know, but it is going to be the most significant case as it relates to law enforcement. And it's going to affect the next 20 years of law enforcement capabilities. All right, everybody. I know that was totally nerdy. And if you made it to the end, I appreciate you. But I just find this absolutely interesting. And I thought, well, maybe somebody else would find it interesting too. So we talked about it. All right. Thanks for joining us. And remember, the Constitution matters, as we just explained. Have a good day.